Hello and welcome to the Ottawa Business Journal's live broadcast of getting businesses ready for the new wage fixing and no poaching law changes. I'm Michael Curran from the Ottawa Business Journal. Thank you for joining us today. We are happy to be joined by about 250 pre-registered guests watching us on YouTube today. Plus, we are live broadcasting to OBJ's LinkedIn, Twitter, and Facebook audiences. I'm very happy to be talking to you about employment law again. I say that because employment law topics, wow, they're extremely popular and relevant to OBJ's audience. Of course, during the pandemic, we've seen so many changes and so many of you have been attuned to these changes. Once again, we have a very timely topic for you here today. Last week on June 23rd, just last Friday, there were significant amendments to the criminal conspiracy provision of the Competition Act. Most notably, the amendments will make it an offense for employers to fix, maintain, decrease, control wages, or other terms of employment, also known as wage fixing agreements. The agreements will also make it an offense for employers to agree to refrain from hiring or trying to hire one another's employments. Sometimes this is called no-poach agreements. The penalties for violating these new prohibitions on wage fixing or no-poach agreements will potentially be very serious, even a prolonged period of imprisonment. As a result, employers will have to be careful not to engage in any conduct that could violate the new prohibition, even inadvertently. Today, we've got not one, but two employment and labor law experts from one of Ottawa's leading firms. I'm referring, of course, to Eamon Harnden, LLP. They've been a partner in many of these broadcasts. I should point out, by the way, all of these are available on OBJ's YouTube channel. So go check them out if you're looking for more information on this particular topic. But today, we are joined by Sarah Lapointe. Welcome, Sarah.
Hi.
Good to have you with us. And your colleague, Peter Baker. Welcome to you, Peter.
Hi, Michael.
Well, listen, great to be with you. As I said, these are very popular. There's a real hunger, thirst to get this type of information. So we appreciate you being here and also for all of the expertise and new information you're going to share, Sarah and Peter. So look, as you know, we've broken today's show into three different parts. The first topic will be looking at these new statutory prohibitions. Topic number two will be the new prohibitions in practice. And number three, defenses, exemptions, and exceptions. And as we often do in these shows, we're going to go to you, our live audience, sometime around 12:25. A reminder that even if whether you're watching on YouTube, LinkedIn, Facebook, or Twitter, you can pose questions through those social media platforms, and I can monitor and moderate them sometime around 12:25. And by the way, don't wait to 12:25 if you hear Sarah or Peter ask something or say something, that's of interest to you. You need some more information. Ask the questions early. That's how to make sure you get your question answered. So, Sarah, you're going to kick us off on topic number one, which, as mentioned, is new statutory prohibitions. Over to you, Sarah.
Perfect. So our goal today is to make sure that businesses are aware of the new changes to the Competition Act, which, as Michael mentioned, came out last Friday, so June 23rd, very fresh off the presses. And we want to make sure that businesses are aware of what's covered so they can avoid accidentally breaching the Competition Act, especially since these breaches would come with some significant potential penalties. Both for the businesses and the corporations, but also for the individuals themselves that are acting on behalf of the employers. So things like directors, officers, HR employees, the individuals that would be potentially entering into those types of agreements. So as Michael mentioned, there's been some changes to the criminal conspiracy provisions of the Competition Act, which has created two new criminal offenses which prohibit entering into a wage fixing agreement or entering into a no-poach agreement. While my colleague Peter will go into more detail on how that applies in practice, looking at it from a big picture perspective, a wage fixing agreement refers to an agreement between two different employers to fix or maintain salaries, wages, or other terms and conditions of employment. And this is interpreted quite broadly. So this can include things like policies, hours of work, bonus, mileage claims. It's not just wages in the sense of salaries. It's really quite broad. In terms of the other new offense, no-poach agreement refers to an agreement between two separate employers to refrain from soliciting or hiring each other's employees. These are sometimes called non-solicit agreements or no-hire agreements. And with these new provisions, they are now generally not permitted unless an employer falls under one of the defined exceptions. And in terms of potential consequences, both the corporate entity or the employer themselves and the individuals acting on behalf of the employer are going to want to make sure they avoid any potential conduct that could contravene these provisions, even inadvertently, because the consequences include a potential imprisonment for up to 14 years, as well as a discretionary fine. In terms of context, there used to be a maximum fine under the Competition Act that was set at $25 million, but that cap has recently been lifted, which suggests that the potential exposure could be even higher depending on the individual's circumstances. When we're looking at offenses under the Competition Act, in terms of the potential proof, the court can infer the existence of an agreement or an arrangement from circumstantial evidence, which will make it doubly important to avoid any potential communications or actions that could be misconstrued as an agreement to enter into a wage fixing agreement or a no-poach agreement. And even though the court can look at the circumstantial evidence, I do note that the allegations still need to be proved beyond a reasonable doubt. So it is the criminal standard of proof that applies and not the balance of probabilities, which means that while inference is possible, they're going to look at everything to see if there might not be another reasonable explanation. Now, because this is so new, these prohibitions are only from last Friday. We don't have case law yet in terms of the potential application of the prohibitions. However, the Competition Bureau of Canada does have some enforcement guidelines that have been published on their website. Now, they're not binding, but they do give a pretty good idea in terms of, from a policy perspective, how the application is going to go for the new prohibitions. And so there are some examples there. If you go on the Competition Bureau website, you can find those guidelines. And today, my colleague Peter is going to be going over some of the examples and the information that's been provided so that you can be more aware of what these restrictions are and what you can do to make sure you stay on the right side of the Competition Act.
Well, two quick reactions to what you said there, Sarah. One is, wow, up to 14 years imprisonment or discretionary fine. I'm understanding why we're talking about this. These are serious consequences. The other thing that just occurred to me is, and I think it was kind of understated when you were speaking, is that this could be, you could see how business people could have these discussions without being completely intentional in them. In other words, they're not calling a meeting and the agenda has a no poaching agreement that's signed by both parties. It might simply, in trying to not compete or have friendly relations between businesses, this type of thing, you could slip into these discussions without knowing it. And any quick comment on that, Sarah?
Oh, absolutely. Peter's going to be giving more examples, but it can be something as simple as two friendly competitors getting together for lunch and being, you know what, we've had a good year this year. I'm thinking I'm going to give our staff a 5% increase. And then the other competitor says, you know what, that sounds about fair. I think I'll do 5% too. And hey, you've just fixed some wages here and we have a potential problem.
Yeah. I'm so glad we just delved into that, because again, I think some people might have had this sense that you're getting together with with the other CEO or company owner and signing some big agreement. That's not necessarily what we're talking about here. But listen, Peter, you're going to dig into all the details. That's what you're doing in topic number 2, which again is new prohibitions in practice. And let's get your take on this, Peter.
Thanks so much. Yeah, so as you've just heard from Sarah about the amendments to the Competition Act, let's now zoom in a little bit on the specific elements of the new legislation, and also looking at these guidelines that Sarah mentioned. And the elements for the offence are basically listed as bullets here. So the first bullet is on applicability. I wanted to just touch on that, starting with some information on the date the legislation came into effect. And you already heard that the prohibitions apply to agreements made between employers on or after last Friday, June 23rd. That's straightforward. But the guidelines from the Bureau also indicate that existing agreements that under the new law would qualify as wage fixing or non-poaching are at risk. So specifically, any conduct by an employer that reaffirms or implements agreements from before last Friday are also at risk. And reaffirming is basically renewing a contract, for example, after it has expired. Luckily, not every further action by a party to an agreement that is already in place will qualify as an affirmation. The guidelines require a meeting of the minds between two employers before the agreement between them can be considered to have been reaffirmed. So essentially, if only one party takes a step to reaffirm an expired agreement, at that stage, neither party is in violation yet. That on the first sub-bullet point on applicability. Then moving on to the second sub-bullet point here, which concerns affiliation. The new prohibitions apply to agreements between unaffiliated employers, and as such, they don't apply to agreements entered into only by affiliated employers. And for example, wage fixing agreements or no-poach agreements between two or more corporate entities that are controlled by the same parent company do not amount to criminal conspiracy under the Competition Act. And so basically this means that conglomerates can freely align their wages internally. Moving on to the third bullet point on your screen, and the definition of employer in the new legislation. The new prohibitions apply to agreements involving two or more employers, and regardless of whether they compete in the supply of a product. And this is interesting. So the conspiracy legislation therefore casts a wide net. It's not just competitors who are prohibited from restricting competition through wage fixing. It's really any two employers are prohibited from doing so. And that's not all about the definition. The definition of employer used in the legislation will not just apply to corporate entities. The definition of who is an employer includes employees such as directors and officers, agents, HR professionals. And in practice, that means that a wage fixing agreement can occur between an officer of a corporation and a director of another company. And this would be considered offside and in violation of the criminal conspiracy provisions. And they could be subject to criminal prosecution without a corporate board's knowledge. So it's therefore advised that companies inform their leadership and officers of these new prohibitions. So next to the fact that individuals who represent the corporation can be considered employers under the law, also the corporations themselves can be subject to prosecution. And it's been made clear in the guidelines that a corporation is at risk if its employees are acting in their capacity as senior officers. And one of the footnotes in the guidelines specifies that this applies to senior officers, and it must really be about directing minds, people who can bind the corporation. So both individuals in the company are exposed to non-compliance penalties here. Then moving on to the last bullet point, sub-bullet point here, which is that the requirement that wage fixing or non-poaching must regard the employer's employees. So basically what this means is that the new prohibition disallows agreements to not solicit or hire each other's employees. So not hiring each other's employees requires the participation of two employers. So not hiring each other's employees is a two-way street. And the guidelines indicate that when a restraint contained in an agreement only applies to one employer, the Bureau will view it as a one-way and not applicable to each other's employees. So maybe a quick example then about the reciprocity requirement here and on no-poach agreement. So let's say that there's a company X, and company X is a consulting company who temporarily embeds its employees in its clients' businesses. And as part of a consulting contract, company Y agrees to not hire any of company X's embedded employees. That's a no-poach agreement. It was entered into by two employers to prevent company's X employees from being poached by company Y. But because the restraint contained in the consulting contract only applies to company X's employees, it's a one-way only, and it does not violate the amended criminal conspiracy provisions. So lastly, on these four sub-bullets, a quick comment about the characterization of the employment relationship. The new prohibitions apply to agreements between unaffiliated employers regarding their employees. So it's important to remember that the legislation is specific to the employment relationship. And while this may seem straightforward, it is of note to point out that this is not always clear. It's not always clear whether a worker is an employee. Whether an employer-employee relationship exists between parties will always depend on the nature of their interactions and the laws that apply. So that's a point of note. Then moving on to the the bottom bullet point on the page about information sharing, and this was briefly alluded to by Michael when he talking to Sarah. It says here that sharing of commercially sensitive information with another employer in the course of collaborative activities could potentially raise concerns. The legislation does not just capture explicit non-poaching and wage fixing agreements. It's good that employers are mindful that information sharing can also be risky. And the example that was given in the guidelines is benchmarking exercises. So where employers essentially compare employment terms, and that's named specifically as a collaborative activity that requires extra care from employers to avoid findings that they're trying to fix wages or other employment terms. Maybe as good as a final thought on topic 2, it's important to note that if an employer is simply reactive, so not actively involved with other employers, this is likely fine. So any attempts of conscious parallelism, as it's described in the guidelines, where you're an employer and you're basically independently aware what your competitors are doing and you're responding to that, that will likely not qualify as dangerous information sharing or wage fixing. That's it for topic 2.
Yeah, Peter, such good details here. Wow. And it is a little bit of a land minefield when I'm trying to understand how you'd walk so carefully through that. But some of the key points I heard, if you're this needs to be unaffiliated employers. So if you're part of the same corporate entity and potentially the company's divided into divisions, those divisions could share information. Of course, that's okay, Peter.
Correct.
Yeah. The other part that really fascinated me, Peter, was your example of a two-way kind of non-poach. So I loved your example of a consulting company placing someone in a separate company and writing a clause saying you may not directly hire this employee. That would not be a breach of this new Competition Act. You would need a both-way agreement, a two-way agreement to poach. Did I get that right too, Peter?
Yeah, fully correct, Michael. Yeah.
Okay. And we have lots of questions, by the way, Peter, coming in, and you almost touched on one of them, but we'll wait here a few minutes. My goodness, a very active board, people with all sorts of questions here, but we'll keep on rolling and we'll go to our third topic, which is defenses, exemptions, and exceptions to the new prohibitions. Peter, once again, you're going to talk us through this.
Yeah, thanks, Michael. And I'll try and keep it short in the interest of time as well. But so as I just discussed, we talked about who falls under the scope of the legislation and in what circumstances. And it's clear from this that the new prohibitions on wage fixing agreements and no-poach agreements are directed at naked restraints. And that's also what Sarah also indicated. So basically where the main purpose of the agreement is to restrict competition. And the Bureau, as as distinguished between these naked restraints and what is called ancillary restraints. And that's also the defense that's being offered, the so-called ancillary restraints defense. So even if you look to be on side with an agreement that's in violation, you could raise this defense and the Bureau might say, okay, you're not in violation of the law. And just quickly on the elements for that defense, under sub-bullet 1, to rely on the ancillary restraints defense, basically you must determine whether the restraint that's in the agreement meets, flows from, or is part of a broader or separate agreement that includes the same parties. So to determine whether this restraint meets the criteria, the Bureau can investigate. Specifically, according to the guidelines, the Bureau may examine the terms of the agreement or the form of the agreement, the functional relationship or lack thereof between the restraint and the principal agreement, or how the restraint makes the principal agreement more effective in accomplishing its purpose. On the second and third sub-bullets, the defense is likely also available when the Bureau finds during its investigation that the restraint is directly related to and reasonably necessary to give effect to the objective of a broader agreement, and the broader agreement doesn't contravene the act. So this doesn't mean that the Bureau will be extremely critical and try to point out all less restrictive restraints that the parties did not use, but the Bureau will, it's not limitless. If the Bureau finds that parties could have achieved an equivalent or comparable arrangement through practical or significantly less restrictive means that were reasonably available to them, then the Bureau will conclude that the restraint was not reasonably necessary and the defense will not apply. And so examples of contracts where the restraint is typically ancillary and where a review by the Bureau is not very likely are, for example, merger transactions or joint ventures or strategic alliances. These are unlikely to constitute criminal conspiracy. Then briefly moving on to the final two exceptions to the wage fixing prohibitions. There's a mention here of Section 4. This provides an exemption for agreements between employers that occur in the collective bargaining setting. So where employers make arrangements between themselves pertaining to collective bargaining with their employees, that's exempt. And then there's a final mention of Section 45(7), and this provides a defense for conduct authorized by an act of Parliament. And that's it for topic 3.
Very good. Very good again, Peter. Very interesting. Again, one of the things I was picking up that if it was a joint venture or merger agreement, it would not be contained in this. That was quite interesting, and also for collective bargaining. And in fact, I think we've got some questions on that. So in fact, we will move to those questions now. Thank you, everyone, for being so active. In some cases, Sarah and Peter, I think some of these questions you may have answered, and we'll just kind of reinforce the point. But we'll move through some of these, and I'll bring them on screen, but I'll read them out for you. Brent Francis says, my lawyers and accountants usually have non-poach clause in their contracts. I'm going to, does this have to change? So that question was from Brent. So I don't know, Sarah or Peter, if you want to tackle this one. My lawyers and accountants usually have non-poach clause in their contracts. Does this have to change?
So I can jump right in on that one. One of the recommendations that we have given these changes is to have those clauses reviewed by your lawyer to make sure that they're up to date based on these new changes. You're going to want to have them look at your clauses, make sure that the circumstances are appropriate. You're permitted to use a no-poach clause in that case, and to make sure the scope of the clause is sufficiently narrow that it will fit under one of the applicable defenses. So that's for sure one of the takeaways we'd recommend is if you're using no-poach agreements, non-solicit clauses, that you should get them updated and you should consult your lawyer on that.
Sarah, I mean, such a good point. We should just underline that just because you've watched 30 minutes of this podcast does not mean that you have enough legal information to go ahead and make those determinations. So, you know, we always, by the way, for all our registered guests, we're going to connect you with Sarah and Peter because we know that you might have some questions and need a follow-up for this. Peter, I'm going to send this one to you because I think you touched on it. And here it comes right here. Dan Foggin, I think is the pronunciation's name. Do you see these new requirements limiting enterprises from conducting salary surveys? So that's an interesting one, Peter.
Yeah, this is definitely going to touch on the whole information sharing gray area part of my my contribution for today. It's we don't really know what the limits are on information sharing at this time. And this does seem to be an example where that could come into play, but without further information on what that looks like, such a survey, it'd be hard to actually say whether it's going to be looked at by the Bureau or if it's totally onside.
It's again a good point. We have this has not been tested in court, so it's early to make those determinations. But a little bit of a red flag went up. Maybe Sarah will send this one your way. And I don't know it, but to our audience, please appreciate that our two legal experts here are seeing these questions, like just for a second. So if there is no comment, just give me the no comment. This one seems to that at the root of this is grants to daycares in this case, but it could be any sort of private sector company. The Ontario government, who gives a wage enhancement grant to daycares, has a sort of fixed wages to early childhood educators. Will this oversee this? I don't know if that might be hard for you to answer, Sarah.
That one's very specific, so I would need context in terms of what's facilitating that wage grant. But if it's based in legislation, there is an exception where wage fixing is permitted, where it's permitted by a law. So if there's a legislation that's enabling this and it's through a government program, in all likelihood, it would be fine.
Yeah. And always, get some more advice and sometimes you of course need some more details. This one's from Ange, I believe his or her name is and I think, Peter, you kind of spoke to this in point 3, but let's check in with you. Public sector salary information is required to be disclosed as part of the public sector salary disclosure sunshine list. How does this legislation impact this?
Yeah, it doesn't immediately strike me as an agreement between two employers.
Exactly, yeah.
That would be my take on that, but I'm not intimately familiar with how that process goes. But the legislation is really aimed at prohibiting competition, where two employers engage in conversation about how they can sort of fix or stop each other, like stop employees from moving around.
Fair enough. Sarah, I think this one's coming your way, and I think you did address this, but you can just reiterate the point. So Katie is asking, because there is a risk of imprisonment as a consequence of breaching these new provisions, if a matter was to proceed to court, would the criminal standard apply as opposed to the civil standard? Do you have a comment? I think, Sarah, you brought that up.
Yes, absolutely. So you're correct. It would be the criminal standard that would apply. So they'd have to prove it beyond a reasonable doubt. And so it would not be the civil standard.
Okay. And maybe we'll try this one to you, Peter. Sean Piers is asking, I work in dentistry. If as an owner with an associate, I have an associate contract indicating they may not poach employees if they leave to open their own practice, is that a problem? So it sounds like two people who are partners in a business, and there's an agreement that if you exit the corporation, you can't poach our employers. That sounds like the one way, but I'm not the expert, Peter.
No, I think you're actually right there, Michael. That was also my direction there. It sounds like a one way, and those are not prohibited.
Okay. Well, listen, we'll start wrapping this up in a second, and I apologize. Yeah, in fact, I think we've touched. There are more questions, but I think they've addressed issues that you have talked to. So listen, we're going to shift then to our wrap up, and we've prepared some takeaways, and we'll bring those up on screen. And I think, Sarah, you're going to give us some of the key takeaways for people tuned in today.
Yes, so there's a few different takeaways. The main one is to make sure you're aware of these new criminal offenses so that you don't accidentally breach the Competition Act, and that you don't engage in wage fixing or no poach agreements by accident without meaning to. And to know that both the companies and the individuals involved could have potential liability here. In terms of proactive steps that can be taken to ensure compliance, one of them is we recommend that you don't enter into a new wage fixing or no poach or non-solicit agreement without first speaking to your lawyer to make sure that you fit under one of these exceptions, and that you don't take steps to reaffirm or enforce existing agreements, again, without having legal advice to make sure that everything is above board. You're also going to want to do, as employers, is update your policies and agreements to make sure they respect the new rules, and that if you have a non-solicit clause, that it falls under one of the exceptions, and that even if it's an exception, that the scope is sufficiently narrow, that you are not imposing restrictions that are not reasonably necessary in the circumstances. And finally, employers should be cautious about sharing commercially sensitive information with other employers, including anything to do with their terms and conditions of employment, to avoid any kind of potential misinterpretation of the situation as trying to fix those terms and conditions of employment. I know I'm going to sound like your classic lawyer, but our recommendation is it's better to be safe than sorry, especially when there's prison and huge fines on the line. So if ever you're in any doubt about whether an agreement you're looking at could breach these provisions, or whether the information you want to share is permitted, our suggestion would be to seek legal advice just to make sure that everything is above board and you're good to go.
That's my takeaway, Sarah. New provisions, very serious consequences. Be careful about having discussions with competitors, that would deal with rate of pay or other employment facts and figures. Yeah, really. And listen, Sarah and Peter, I think this is one of those topics that really underlines why, whether you're in the private sector or public sector, you need great legal advice. So we're going to bring up your contact info and underline again that we've scratched the surface of this issue. And if you, and every situation, I've learned that in operating some of my own businesses, when it comes to employment law, every situation is unique, and you should get some quick legal advice if you've got any questions. So right there on screen, you can contact Sarah. We get the phone and email, and same thing for Peter, phone and email. And with that, Sarah and Peter, I want to thank you very much. Another great episode from our friends at Eamon Harrington. A reminder that we've done this many times before. So if you really like these, you can go to OBJ on YouTube. Just go Ottawa Business Journal YouTube. Look for a playlist, and you'll find some of these live broadcasts. There are several that deal with employment and labor law. So thank you, Sarah, for joining us. Thank you, Peter. Have a wonderful day.
Thanks for having us.
And as we're signing off here, just a reminder that this is a live broadcast on many different platforms. The second it stops being live, it is available for replay. So if you've watched this and you're like, oh my gosh, my CEO or C-suite executives, my HR team needs to know this, good news. You can send them the link. And a reminder just generally for OBJ to check our website for information on these legislative changes, things like this, all sorts of business news and information data on our website. Again, that's obj.ca. I highly recommend, that you subscribe to our weekday, Monday to Friday, email newsletter, OBJ Today. It'll keep you updated. And listen, we've got this great new program called OBJ Insider. And if you want access to the premium digital content, as well as some other perks like getting the quarterly news magazine mailed to you, when you visit obj.ca, look in the top right corner and it says Become an Insider in red. Click that. And if you're watching on YouTube, one last thing that I ask of you, please click the red subscribe button and the little bell icon. That bell icon makes sure that you get a notification when we're live on YouTube. Well, that's all the time we have for today. On behalf of our friends at Eamon Harnden LLP and Ottawa Business Journal, I wish you a wonderful day. Stay tuned for more great content. Cheerio.